Welcome to the State Board of Pardons and Paroles. This presentation is designed to describe the agency, its service to the citizens of Georgia, and how public safety is enhanced as a result of the board's decisions. This presentation will enable you to learn about the agency's constitutional authority, responsibilities, and our public safety mission. Our mission: to serve the citizens of Georgia by exercising the constitutional authority of executive clemency through informed decision-making, thereby ensuring public safety, protecting victims' rights, and providing offenders with opportunities for positive change. In the next several slides, we will explain the history of the Parole Board, its constitutional powers, the development of the clemency process in the state of Georgia, and the parole decision process of releasing offenders to community supervision. Most Georgia inmates, according to law, have a right to be considered for parole, but they do not have a right to be released on parole. The board has a scientific, data-driven process for release considerations. State inmates are considered for parole automatically, unless required to serve the entire sentence as mandated by Georgia law. Inmates serving a non-life sentence for one or more of the serious violent felonies committed on or after January 1, 1995 are not eligible for parole and must serve 100% of the prison term imposed by the judge. The serious violent felonies are murder, rape, aggravated child molestation, aggravated sodomy, aggravated sexual battery, armed robbery, and kidnapping. Also not eligible are those inmates sentenced as a recidivist or sentenced to life without parole, or those under a death sentence. By law, all other inmates in state custody are considered for parole at least once during their prison term. The Parole Board was created by the legislature in 1943 to determine clemency for adult offenders. Georgia voters ratified the landmark amendment to the state constitution. There were 3 voting members originally. In 1973, the board was expanded to 5 members. Currently, board members are appointed to 7-year staggered terms, subject to confirmation by the state Senate. As a result, the members are insulated from political pressures and are able to act in the best interest of the state. The members were assigned the power to grant pardons, paroles, and other forms of clemency. The board is the only Georgia authority with the ability to commute death sentences. If commuted, the board may reduce the sentence to life with parole eligibility or to life without parole eligibility. The board members render clemency decisions to include parole decisions, parole revocation decisions, pardons, restoration of rights, and death sentence decisions. From 1943 until 1978, parole decisions were made on a case-by-case basis. Board members considered several factors, but the factors were not specific, and they were not ranked in priority. The lack of specifics could imply decisions were not equitable. In 1977, the board began to study a way to provide a scientific and objective means of structuring the board members' discretionary authority into the determination of the length of incarceration and who will be released on parole. This began the procedure to formalize the board's decision process, making it fully explainable and open to public scrutiny. It would guarantee the equitable treatment of all inmates, assuring that inmates with similar behavioral and criminal characteristics, whether in South Georgia or North Georgia, will be incarcerated for similar periods of time. Using federal grant funds, a 2-year research project was conducted. This resulted in the creation of a pilot program focusing on a test group of offenders ages 16 to 21. The project allowed for periodic evaluation and adjustments. Crime severity levels were determined by the board based on sentence length and the severity of the crime. Based on the pilot study, it was found that the board agreed with the crime severity levels and the parole risk 90% of the time. The parole board established the new guidelines at that point. This project was deemed successful and factors were developed for all offenders. The guidelines were expected to affect 85 to 95% of all cases considered. Lifers, inmates sentenced to life with parole eligibility, are currently not included under the guidelines. The Parole Board's parole decision guidelines were originally based on the pilot program in 1978 and were implemented in 1979 and made law in 1980. The law reads in part as follows. The Board shall adopt, implement, and maintain a parole guideline system for determining parole action. The guideline system shall be used in determining parole actions on all inmates except those serving life sentences. The system shall be consistent with the Board's primary goal of protecting society and shall take into consideration the severity of the current offense, the inmate's prior criminal history, the inmate's conduct, and the social factors which the Board has found to have value in predicting the probability of further criminal behavior and successful adjustment under parole supervision. The Parole Board's guidelines are not utilized in all parole-eligible cases. Offenders sentenced to life with parole eligibility are considered according to the sentencing law in effect at the time the crime was committed. Prior to January 1, 1995, an offender serving life with parole eligibility became eligible after 7 years in prison. From January 1, 1995 through June 30, 2006, state law mandated the same type of offender committing the crime within that period serve 14 years before being considered for parole. As of July 1, 2006, life-sentenced offenders who are eligible for parole committing the crime after June 30, 2006 must serve 30 years in prison before they can be considered for a parole release. State law makes exceptions for some offenders. Drug offenders and offenders serving for child molestation, home invasion, and trafficking sexual servitude who are serving life with parole eligibility must serve 7 years prior to parole consideration, regardless of the crime commit date. If parole is denied in a life case, the Board must reconsider the case, and by Board rule, a decision is made to determine when that reconsideration will occur, a period of 1 year up to 8 years. The parole decision guidelines are based on three major components. The parole risk factors, which included at the time factors such as prior incarcerations and age at first commitment, the crime severity levels, and the time to serve grid. The following slides detail this composition. All common criminal offenses are arranged according to severity by the Board. Level 1 is the least severe. Examples: entering an automobile or first-time drug possession for small amounts. Level 8 is the most severe, such as robbery or aggravated assault. There are factors which are considered when determining the crime severity level for a particular offense type. Factors that can determine the crime severity level may include, but are not limited to, use of a weapon, dollar and drug amounts, the number of criminal counts, and an injury to a victim or attempted injury. For example, dollar and drug amounts. There is a big difference regarding the crime severity level between an individual that has a small amount of illegal drugs, such as 1 gram of cocaine, versus an individual that has 28 grams of cocaine. The Board gives the two cases a different crime severity level based on that factor. Another example is the dollar amount in a burglary or theft. The lower the monetary value of the theft means a lower crime severity level. Likewise, a crime involving something taken of great monetary value results in a high crime severity level. Here's a look at the crimes as they appear on the crime severity level chart. Let's use burglary as an example. Burglary falls under multiple crime severity levels. There is a crime severity level 1, burglary non-dwelling 1 count with the value of the theft less than $300. Crime severity level 2, burglary non-dwelling 1 count with higher dollar amounts. Crime severity level 3, burglary with multiple counts and even higher dollar amounts. Crime severity level 4, burglary, 6 or more counts and more than $5,000 in value. Crime severity level 6, burglary of an unoccupied dwelling. And crime severity level 8, burglary of an occupied residence, meaning someone was at home at the time the crime occurred. Unless otherwise specified, if the inmate is serving for an attempted offense, the offense will be rated 1 severity level less than where the actual offense is listed. The higher the severity level of the offense, the more serious the parole board views the crime. Normally, the board considers the highest crime severity level offense for which an individual has been convicted as the controlling crime severity level. Sentence length may be a factor. According to state law, some offenses are not parole eligible. State law states that the following sentences are not eligible for parole if serving less than a life sentence. Those sentences or convictions are aggravated sexual battery, aggravated child molestation, aggravated sodomy, armed robbery, kidnapping, rape, and murder. Inmates convicted of a fourth felony and sentenced as a recidivist and those sentenced to life without parole are also not eligible for parole consideration. In 2015, the board began a revision of the parole decision guidelines. A statistical analysis of parole cases identified new significant predictors of public safety risk, defined as a felony arrest within 3 years of the prison release. For the first time, risk factors and their weights were identified separately for males and females. For all cases considered for parole on or after July 1, 2017, the new system is used to compute an offender's parole risk score. These are the current parole risk factors. A, primary offense is a property crime. B, probation or parole violation. C, number of felony arrests. D, number of misdemeanor arrests. E, Department of Corrections validated gang member. F, age at current prison admission. And G, any violent disciplinary report while in prison. In addition, whereas previously the board focused on predicting a conviction within 3 years of the release, currently the board is focused on predicting whether there will be a felony arrest within 3 years of the release on parole. If the primary offense is a property crime, the risk factors include probation or parole violation, number of felony arrests, and number of misdemeanor arrests. If there is a felony arrest and a misdemeanor arrest combined in the same episode, it will count as one felony arrest. Another factor is the Georgia Department of Corrections validated gang member, a risk factor for male offenders only. Available data does not support it as a risk factor for female offenders. Other risk factors are, again, age at the time of the offender's current admission and any violent delinquent report while in the custody of the Department of Corrections. This is the Parole Decision Guidelines Time to Serve grid. The hearing examiner cross-references the offender's crime severity level and the risk to reoffend score on the guidelines grid component of the Parole Decision Guidelines system. The guidelines grid provides a months to serve or a percentage of the prison sentence to serve recommendation for the board's consideration. This action results in the Parole Decision Guidelines recommendation regarding parole to include how much of the sentence the offender should serve prior to parole, or if it is recommended parole be denied. There are 3 risk categories, low, medium, and high. That means for each different crime severity level, 1 through 7, there are some offenders who are a higher risk to reoffend than others. The board adopted various percentages of the sentence for level 8 offenses rather than an across-the-board percentage. The law governing parole guidelines requires that the guidelines take into consideration not just the severity of the crime, but the inmate's conduct and the social factors which the board has found to have value in predicting the probability of further criminal behavior. Once the board receives a parole recommendation based on application of the guidelines, the board members vote individually to accept or reject the months to serve recommendation. If the majority accepts the recommendation, the tentative parole month, or TPM, is established, and the inmate is provided with written notification. A board decision to grant parole is always tentative and may be changed or withdrawn at any time. Reasons for making a change may include new information received about the case, including prison misconduct. If the guidelines recommendation regarding parole is rejected by the board members, the members make a discretionary decision which will lengthen or shorten the period of confinement, or the board may deny parole. The inmate is advised in writing of a parole denial or deviation from the guidelines and the process to appeal the decision. Once a tentative parole month is established, the offender is able to work with the counselor in prison to schedule and complete required rehabilitative programming. A TPM also increases inmate morale by eliminating release uncertainty. Courts may take into account the board's parole decision guidelines when sentencing the offender. On these next few slides, we review the process from sentencing to a parole decision. There are 7 steps. 1. The offender is sentenced. 2. Offender administration at the Department of Corrections receives the sentencing information and computes the sentence. 3. The parole board's clemency staff begins preparing the offender's case file based on the sentence computation. 4. Clemency hearing examiners prepare the case for the board members to consider. 5. The board members vote the case. 6. The board's decision is made public. And 7. If a tentative grant is made by the board, and following a final review, a release date may be set and the offender is released on parole. As we move forward, more details regarding these processes are explained. State law determines if an offender is eligible for parole and when. The parole board considers only those cases that are legally eligible for parole. The following slides also give an overview of the parole decision-making process with more detail. So let's look at the process. The offender is sentenced. The court clerk sends a sentencing package to the Georgia Department of Corrections Offender Administration Unit. This unit computes the time to serve dates, including the start sentence or controlling date, and the end of sentence or max-out date. The Georgia Department of Corrections sends the information electronically to the parole board. The Department of Corrections system known as SCRIBE, or Statewide Correctional Repository and Information System, communicates electronically with the parole board's case management system known as GPADS, the Georgia Parole Evidence-Based Data System. The parole board's clemency division includes teams of staff called GPADS teams. The GPADS teams are in charge of processing the case before it is sent to the board members. The case is initialized, which means the controlling date or sentence start date is determined as a result of the information sent by the Department of Corrections, and the parole eligibility date, commonly known as the PED, is established. Multiple sentences that have different control from compute dates will determine the offender's parole eligibility date. Next, investigations are requested from parole investigators. These include both legal and personal history statements. A legal investigation provides the circumstances of the crime from all of the different agencies that may be involved. A personal history statement gives the inmate the ability to provide family history and his or her version of the circumstances. When the investigations are received, the case is sent by the GPEDS team electronically to the hearing examiner to prepare the case for a board decision. Hearing examiners then prepare the case for consideration by applying the parole decision guidelines system. The guidelines utilize the crime severity level, nature of the offense, criminal history, parole risk factors, and other available information. The case is forwarded to the board with the guidelines recommendation or the months to serve representing the portion of the sentence that should be served prior to being released on parole. Once prepared, each case file is sent electronically to the board. This is not a face-to-face decision involving the inmate. In Georgia, parole decisions are not made at a hearing where the inmate would be present. The board members individually consider and electronically vote each case. The board members have the opportunity to see every document that is in a case file. This includes letters advocating for the offender's release, information opposing a release, and circumstances of the crime. The electronic voting system recognizes 3 like votes. If there are 5 votes, then the highest vote of the lowest 3 is selected. For example, the board members vote 22, 24, 26, 30, and 36 months for an offender to serve on their prison sentence. In this scenario, because the lowest 3 votes are 22, 24, and 26, the board decision is set at 26 months, again the highest of the 3 lowest. The case moves electronically to the guidelines coordinator to confirm the board decision. If parole is denied, the inmate is notified and the case is electronically suspended until the appropriate time for reconsideration if required. If the board members deny parole, the offender will then max out and be released when the prison term ends. If the inmate has more than 5 years from the date of the decision to deny parole, the board will review the case again after 5 years. In addition, a max-out decision does not mean that an inmate cannot earn performance incentive credits. The inmate may still be granted parole should the board determine the offender can be released based on PIC earned. The board may also reconsider an earlier decision and then deny parole if it receives new information regarding the case. New information may include a recent disciplinary charge or a new criminal charge. If a life-sentenced inmate who is parole eligible is denied parole, the board will set a reconsideration date within a time frame of 1 year to 8 years. If parole is granted for a lifer, a life-sentenced inmate who is parole eligible, preconditions to parole may be set for the offender by the board. Preconditions may include residential substance abuse treatment, work release, or sex offender programming. Hearing examiners are responsible for setting referrals. In other cases, if parole is granted, then the release process begins. If the TPM is a date in the future, the case is electronically suspended until time to begin the release process, which is normally 3 months prior to the tentative parole month. 90 days prior to the tentative parole month or the projected PIC date, the case is sent by the GPEDS team to the hearing examiner to conduct a final review. The final review takes into account the following: the inmate's conduct, program completions, and information from victims, law enforcement, the inmate's family, and the courts. All must be addressed prior to release. The inmate may also have earned performance incentive credits known as PIC. PIC credits may be earned during the offender's incarceration with the Georgia Department of Corrections for completing the inmate's case plan to include work details and educational or vocational program completions. Prior to the TPM, the parole board is notified of an inmate's PIC by the Department of Corrections. Each PIC credit equals a month and means the offender may have his case reviewed by the parole board for release that amount of time prior to the TPM. 1 PIC earned means the board may move the inmate's TPM up 1 month. An offender may be able to earn the maximum amount of PIC, a total of 12, meaning the inmate's TPM could be advanced up to a year earlier. Note that performance incentive credits are awarded at the board's discretion. The inmate file is routed to the GPEDS team for screening. The case is screened for residential plans and special conditions. This is the verified parole plan. If necessary, the verified parole plan is sent to the Department of Community Supervision to be approved. Parole plan verifications are required on all lifers and sex offenders, also for those offenders required to have electronic monitoring, and for inmates that have no contact orders and banishments. The county of conviction is then notified of the release date. Notifications are sent according to Georgia law. The inmate is then released to the Department of Community Supervision. The parole board has the authority to issue a pardon to an offender convicted of a felony in Georgia. A pardon is an order of official forgiveness and is granted to those individuals who have maintained a good reputation in their community following the completion of their sentences. A pardon is an official statement attached to the criminal record that says the state of Georgia has pardoned the crime. It does not expunge, remove, or erase the crime from the offender's record. It may serve as a means for a petitioner to advance in employment or education. A pardon applicant must wait 5 years after the completion of all sentences to include any parole or probation. The wait period is 10 years for a registered sex offender who is seeking a pardon. The applicant must be crime-free during these periods. Applicants may seek restoration of civil and political rights, which restores that person's right to sit on a jury, seek public office, or be a notary public. Applicants must wait 2 years after the completion of all sentences in order to apply for a restoration of civil and political rights. A person's right to vote is automatically restored after the completion of all sentences. The person will need to re-register at the local registrar's office. When seeking a pardon, restoration of civil and political rights is included in this application process. A person granted a pardon is also restored his or her civil and political rights. A person may decide to apply only for restoration of political and civil rights without seeking a pardon. An applicant may also seek to have firearm rights restored and may do so when applying for a pardon. The parole board cannot pardon felony convictions from other states. If a citizen living in Georgia has out-of-state felony convictions and wants the right to bear firearms, the board can grant civil and political rights on those convictions and restore firearm rights within Georgia only. However, the individual cannot travel outside of Georgia in possession of a firearm. If the person does, charges of possession of a firearm by a convicted felon could be applied by the other state or the federal government. Several revisions have been made to the pardon application process in Georgia over the last several years. The application requires more information from the applicant than ever before, allowing board members to make the best possible decision in each case. State law requires that the board send notifications to the district attorney and registered victims when a former offender is seeking a pardon in specific cases. The board determined it would exceed the statutory requirements and now sends these notifications in all pardon applications. When a pardon is granted by the parole board after receiving a protest from the district attorney, according to statute, included on the pardon certificate is information justifying the pardon. The Georgia Office of Victim Services notifies registered victims if a pardon is granted. In addition, the board now has two separate pardon applications, one for an offender who is required to register with the state as a sex offender, and another application for all other convicted felons. Information the board requires from the pardon applicant includes education, military service, employment history, substance abuse and mental health history, information describing how the former offender has contributed to society and the community, the applicant's version of the offenses that were committed, and the applicant's justification for being granted a pardon. Thorough investigations on the applicant are conducted by clemency staff. Anyone requesting the restoration of firearm rights must agree to a face-to-face interview with one of the board's certified criminal investigators. Offenders required to register as a sex offender must complete a more detailed application. Additional requirements include a 10-year crime-free waiting period following the completion of all sentences, including parole or probation, submission of a psychosexual evaluation, they must submit to a polygraph, and provide a current copy of the applicant's most recent risk level evaluation as assigned by the Sexual Offender Registration Review Board. Thorough investigations on the applicant are conducted by clemency staff. All restoration of civil and political rights and pardon investigations are completed by parole investigators or pardon administration staff and require a face-to-face interview with a parole criminal investigator. If an applicant is seeking restoration of firearm rights in addition to all other pardon requirements, the applicant must submit 3 letters of reference from non-family members. The types of pardon and restoration of rights applications can be found on the agency's website. The board's pardon process is thorough, and cases generally take several months to complete to include the board's decision. The Field Services Division is the division of the agency that manages the processes relating to parole violations, commutations, and the Interstate Compact. Violations of parole conditions by offenders are quickly addressed by the division in order to bring the offender back into compliance. If necessary, the offender's parole is revoked and the offender is returned to prison. In addition, the division facilitates requests for commutations of sentences. The division also completes the transfers of offenders for supervision in other states and transfers of offenders to be supervised in Georgia. The Field Services Division works directly with the Parole Board and the Department of Community Supervision to determine what appropriate action is necessary in the best interest of public safety when responding to parole violations. The actions or post-clemency decisions are made by the Field Services Division under the authority of the State Board of Pardons and Paroles. The District Operations Manager, or DOM, is a subject matter expert within the Field Services Division. Under board policy, the District Operations Manager assesses alleged parole violations and determines the appropriate sanctions. 10 District Operations Managers work in the division, and each is the primary contact for one of the 10 state judicial districts. This map shows the 10 judicial districts in the state, and it is further broken down into judicial circuits within each district. For example, Coweta is a circuit within Judicial District 6. It encompasses the counties of Coweta, Heard, Meriwether, Troup, and Carroll. The district operations managers for the Parole Board, in conjunction with the Department of Community Supervision, are responsible for determining the appropriate response to parole violations. Parole violations may be of a technical nature or be the result of an arrest or a new criminal offense. A technical parole violation is a failure to comply with standard or special conditions of parole. For example, failing to follow an instruction by a community supervision officer, or a special condition required by the parole board, such as electronic monitoring. A new criminal offense is an arrest for a new alleged misdemeanor or felony offense that has occurred during the period of supervision. These are standard conditions that all offenders must comply with if released on parole. Each offender on parole will have a supervision plan that will include obeying all instructions, following all laws, being truthful, and paying any necessary fees to include supervision fees or restitution. Those on parole must not commit criminal acts and are required to immediately notify the supervision officer if arrested for any offense, including a driving citation. Offenders on parole are subject to a search of themselves and their property, even without a warrant, and they must not possess a firearm or any type of deadly weapon. Permission is required for the offender to change residences. Failure to get permission can be considered absconding or escaping supervision and would be a parole violation. Failure to report or be able to be located by the supervision officer is a violation. Fee payments, including court-ordered fees, must be paid regularly. Failure to make fee payments can be a parole violation. Unless exempt, all offenders on parole are required to maintain employment, be actively seeking employment, or furthering their education. If serving a split sentence, the offender must abide by all terms of probation imposed by the sentencing court. There are special conditions the board may mandate that the offender on parole would be required to comply with. They may include banishment from a location, a city or counties, a no-contact order, such as having no contact with a victim, required completion of or attendance in a substance abuse treatment program, mental health counseling, and possibly electronic monitoring. In addition to previously discussed requirements, sex offenders will have additional parole conditions. There are 22 special conditions for sex offenders. Among them are global positioning system monitoring, sex offender counseling, and polygraph examinations. In addition, access to the Internet is restricted, or in some circumstances forbidden for many of these offenders. If authorized, it is strictly monitored by the supervision officer. The handling of parole violations requires continuous communication between the supervising officer, who works for the Department of Community Supervision, and the district operations manager with the parole board. Parole supervision is the responsibility of the Department of Community Supervision, or DCS. In 2015, House Bill 310 created DCS Supervision Authority. DCS is responsible for ensuring that offenders are following parole conditions and court-ordered mandates. Violations of parole are identified by the Department of Community Supervision. If the Community Supervision Officer, with the approval of the Assistant Chief or Chief, determines that a parole violation has occurred, a parole board warrant may be appropriate. The supervising officer may request an expedited warrant via telephone call to his or her district operations manager, explaining to the DOM the alleged violations. If the need for a warrant is not immediate or an emergency situation, then the DCS officer submits a written delinquent report to the district operations manager detailing the allegations of the parole condition violations. If a board warrant has been issued and the offender is in custody, the warrant places a non-bondable hold on the offender so that the offender will not be released from custody until further action is taken by the board. If an offender is wanted by the board and the offender is not in custody, the warrant will be placed in GCIC, the Georgia Crime Information Center, making law enforcement aware that the offender is wanted and he or she should be taken into custody immediately. The temporary revocation warrant, or TRW, is issued when the offender is actively avoiding supervision or has absconded. The TRW is entered into GCIC and NCIC, the National Crime Information Center. The TRW effectively stops the offender's time from running. An expedited warrant may be requested from the parole board under certain circumstances. They include if violations have occurred and the offender is in the supervision office or in the presence of his community supervision officer when it is determined there may be a need for a warrant, or the supervision officer learns that the offender has been arrested for a new criminal offense and needs the warrant immediately to ensure that the offender does not post bond and is subsequently released from custody. Or the offender is not in custody but has technical violations that require immediate attention. Or the supervision officer has learned that the offender has outstanding criminal charges. If violations have occurred, the community supervision officer may request a warrant via a delinquent report. A delinquent report is a report completed by the community supervision officer seeking a board warrant. The delinquent report contains a summary of the supervision of the offender, the circumstances of the parole violations, the type of warrant requested, and a recommendation as to the next course of action. If the offender has committed violations but is deemed not to be a risk to public safety, intermediate sanctions may be applied in lieu of pursuing a revocation of the offender's parole. Intermediate sanctions may include, but are not limited to, a verbal reprimand, ordering the completion of community service hours, assignment to treatment or programming, conducting an administrative hearing with the offender, or placing the offender on electronic monitoring. Secure sanctions may be applied that could involve the offender being placed in custody for short-term incarceration. Intermediate sanctions are applied when there is not a risk to public safety from the offender and applied with the intention of correcting behavior and returning the parolee to full compliance with parole conditions. The board has several sanctions or treatment options that are secure alternatives to parole revocation. They include assignment to a parole and probation detention center. This is a 3 to 6 month program at a Department of Corrections facility for male or female offenders on parole who exhibit chronic technical violations, misdemeanor arrests, and low-level felony arrests. The Valdosta RSAT program, or Residential Substance Abuse Treatment Program, is a 9-month prison-based substance abuse treatment program. The program is for males with chronic substance abuse issues who have been unsuccessful in completing community-based treatment. The Pulaski RSAT program is also a 9-month prison-based substance abuse treatment program for females with chronic substance abuse issues who have not had success with community-based treatment. The Transitional Center program is designed for those parolees who are chronic technical violators with unemployment issues. In this program, the Department of Corrections requires no pending charges on the offender in order for placement in the program. Parole violations by the offender may result in a revocation of parole and the offender being returned to the custody of the Department of Corrections. State law gives the board the authority to apply sanctions up to revocation if necessary. State law provides for the offender who has violated parole to have a final hearing regarding revocation that is held before one of the 5 parole board members. Any felony conviction or a misdemeanor conviction involving an injury to a victim resulting in a period of incarceration will result in automatic revocation of parole. No final revocation hearing will be held. A waiver eliminating a need for a final hearing may be signed by the offender. Information regarding the waiver process will be explained later in this presentation. When a parole violation is determined to be serious enough to pursue revocation, the community supervision officer, with approval from a district operations manager, will present the violations and inform the offender that he or she has the option of signing a waiver of a final hearing or appearing in person before a parole board member at a final revocation hearing. The offender charged with parole violations may waive the right to a final revocation hearing if first informed of the rights pertaining to the hearing and of the consequences of waiving the hearing. Parolees who waive their rights to a final hearing via a standard waiver of final hearing form are returned to prison and will be automatically reconsidered for parole within 6 months from the date of the arrest on the criminal or board arrest warrant, whichever occurred first, as long as the offender is not convicted of a new offense. This is the standard waiver of final hearing form referenced earlier. This is the detention center waiver of final hearing form. As referenced earlier, the parole and probation detention centers are utilized in lieu of revocation to general population. Signing the detention center waiver avoids the final revocation hearing. The nolo contendere form is utilized when the only violations are alleged criminal offenses. By signing this waiver, the offender does not admit guilt to the alleged criminal offense, but agrees with parole revocation without a final hearing being conducted. 6 months after the arrest, the board will reconsider the offender's case once the offender has notified the board that the offender was not convicted. Prior to proceeding to a final revocation hearing, probable cause must be established. Probable cause can be established in the following ways. A preliminary hearing may be conducted involving the parolee. The parolee can sign a waiver of preliminary hearing, or the parolee can admit to a violation in the presence of a third party. Probable cause may also be established if the parolee has been convicted in a court of record during the current supervision period, or if he or she was in absconder status at the time of an arrest. The notice of final hearing is prepared by the Department of Community Supervision Officer and then approved by the Parole Board's District Operations Manager. The notice of final hearing is presented to the offender 3 to 5 business days prior to the date of the final hearing. The notice of final hearing is written notification to the parolee detailing the alleged violations of the conditions of their parole. It includes the date, time, and location for their final revocation hearing, and the parolee's procedural due process rights. A parolee about to go before a board member for a final revocation hearing has certain rights. The notice to the offender provides him or her with the following rights: the disclosure of evidence introduced against him or her at the final hearing. This right shall not require the parole board to disclose to the parolee any confidential information contained in the board file which would have no direct bearing on the matter or parole revocation. The parolee has the right to be heard in person and present witnesses and documentary evidence. An offender may request to be represented by counsel. If the parolee desires an attorney but cannot afford to hire one, he or she may request the board appoint an attorney for representation. Counsel will not be automatically provided in every case. The parolee has the right to confront and cross-examine adverse witnesses unless the board determines that disclosure of a particular witness's identity would cause that person or a member of that person's family to be at risk of harm. The parolee has the right to request the board to subpoena witnesses and documents on his or her behalf as provided for in state law. The board has the power to issue subpoenas to compel the attendance of witnesses at the final revocation hearing. The board also has the power to issue subpoenas for the production of documents or written evidence relevant to the case. Requests for subpoenas may be made by the community supervision officer, the offender, or the offender's counsel and should be forwarded to the appropriate district operations manager. At the final hearing, one board member presides on behalf of the full parole board. After hearing evidence regarding the alleged parole violations, the presiding board member rules guilty or not guilty on each parole violation listed on the notice of final hearing. If the presiding board member finds guilt on any count, the case is sent to the full board with a recommendation from the presiding board member for a vote on revocation of parole or continuation on parole. The final revocation hearing is an informal hearing and not a court proceeding. The formal rules of evidence, including hearsay, do not apply to this informal hearing, and any and all relevant evidence and testimony may be allowed at the discretion of the presiding board member. The parole board now conducts final hearings by video conferencing, or what is referred to as a virtual final hearing. This process includes the following procedures. The parolee is transferred to the Georgia Diagnostic and Classification Prison in advance of the hearing. The Community Supervision Officer, state witnesses, and offender witnesses testify from remote locations and are connected by video conferencing. The board member can preside from a separate location or virtual hearing location. If the presiding board member finds the parolee guilty of any of the alleged violations, the parolee will remain at the Georgia Diagnostic and Classification Prison pending the full board vote. The recommendation from the individual board member may be to revoke parole and return the offender to the general population of the Department of Corrections, or refer the offender to a detention center, residential substance abuse program, or transitional center. If the presiding board member determines that revocation is not appropriate, the parolee will be processed out from the prison and returned to the county jail pending the full board vote. If the full board agrees, the offender is returned to parole supervision. The Interstate Compact Unit of the Field Services Division allows for offenders, inmates, and parolees to be paroled from a Georgia prison or transferred to another state for community supervision, and for Georgia to receive and supervise offenders from other states. The Interstate Commission for Adult Offender Supervision ensures identical guidelines for all states on how to handle the transfer of adult offenders from one state to another. Inmates can be paroled via the Interstate Compact to any of the 50 states, the District of Columbia, Puerto Rico, and the United States Virgin Islands. The Georgia State Board of Pardons and Paroles operates under Georgia Code 42-9-80 and 42-9-81 and 42-9-82, and the Interstate Commission for Adult Offender Supervision rules, which have the force and effect of federal law. ICOTS is the Interstate Compact Offender Tracking System. It is a web-based system that facilitates the transfer of supervision for probationers and parolees from one state to another. A $100 fee is assessed to the offender to pay for facilitating the out-of-state transfer request. Procedures performed through ICOTS include transfer requests, notifications of departures, notifications of arrivals, supervision progress reports, violation reports, and case closure notifications. Miscellaneous information and communications can also be sent and received through ICOTS. The Interstate Compact Unit also handles Immigration and Customs Enforcement, or ICE, detainers. If applicable, ICE will file a detainer on an inmate with the Department of Corrections. At the tentative parole month, inmates determined to be non-U.S. citizens are released to ICE on a quarterly basis. If the inmate chooses to fight deportation, he or she will be returned to prison. If ICE is unable to deport the individual, the board will make a decision regarding whether to release the offender to parole supervision. The District Operations Manager assigned to the Interstate Compact Unit responds to violations committed by Georgia parolees supervised out of state and out-of-state parolees supervised in Georgia. Actions may include issuing warrants, conducting hearings to evaluate violations to determine probable cause for a final revocation hearing, and coordinating extradition to return to Georgia parolees who violate parole conditions while under supervision in another state. The parole board has the authority to commute an offender's sentence to time served. Offenders serving parole may petition to have their prison sentences commuted by the board. Offenders serving parole may have their sentence terminated through a commutation. The process is completed by the Field Services Division. The offender must meet specific requirements to request a commutation. They must have served a minimum number of years on parole, and they must be recommended for commutation by the supervising officer. The district operations managers conduct a thorough investigation of the cases meeting the criteria for consideration by the board. The district operations manager submits the case to the parole board with a recommendation. The Georgia Office of Victim Services is a division of the State Board of Pardons and Paroles. The office represents three state agencies, which are the State Board of Pardons and Paroles, the Department of Corrections, and the Department of Community Supervision, thereby creating a single point of contact for crime victims during the post-conviction phase of the criminal justice process. Offenders either incarcerated or on community supervision may have registered victims. The office's mission is to provide post-sentencing support and information to crime victims, their families, and members of the community. The State Board of Pardons and Paroles is recognized for its leadership role in the advocacy of victims' rights. In 2005, the Parole Board and the Department of Corrections combined victim services units to form the Corrections and Parole Board Office of Victim Services. This afforded both agencies the opportunity to accommodate victims by providing the highest level of customer service. On July 1, 2015, with the creation of the Department of Community Supervision, the office began serving victims for all three agencies and is now the Georgia Office of Victim Services. The Georgia Office of Victim Services ensures registered victims' voices are heard throughout the post-conviction phase. State law makes it mandatory that registered victims are given notice regarding offenders in prison, pending parole considerations, and for offenders under community supervision. The Georgia Office of Victim Services meets and exceeds statutory requirements regarding crime victims. The Georgia Office of Victim Services provides crime victims, their families, and members of the community with the opportunity to register in order to receive post-sentence information about the offender or offenders in their case. Individuals can initiate the registration process by sending at least one of the following: a victim impact statement, a victim notification request form, a protest letter, or any written correspondence to the Georgia Office of Victim Services to request notifications. All documents can be forwarded to the Office of Victim Services via postal mail, electronic mail, online forms, fax, or hand delivery. Once registered, written confirmation of registration will be provided along with a personal identification number or PIN. Using their PIN, victims can access the Georgia Victim Information Program, an automated 24-hour, 7-day-a-week phone line, to receive their offender's current incarceration location, parole status, or the scheduled release date. Registered victims will receive the following notifications when applicable regarding convicted offenders: when the offender is being considered for parole, if the offender is being considered for a medical or compassionate reprieve, if the offender is being considered for placement in a transitional center, if the offender's custodial status changes, if the offender is released from custody, if the offender escapes, is recaptured, or dies in custody, and if the offender is seeking a pardon. By statute, the board is required to send notifications in a limited number of pardon application cases. However, the board notifies all registered victims regarding each pardon application received. The Georgia Office of Victim Services serves as the liaison between crime victims and the Department of Community Supervision to address restitution-related matters. Restitution is court-ordered monetary compensation for crime victims. A legitimate order for restitution may be applied to the offender during sentencing, and the amount and manner of payments are determined by the courts. Once an offender is under community supervision, officers facilitate and monitor offender restitution payment compliance. The Georgia Office of Victim Services meets the needs of crime victims by providing various services and programs. Victims' Visitors Days are conducted across the state by the Georgia Office of Victim Services. Crime victims and their families who attend receive information concerning the current status of their offender and can register to receive future notifications regarding the status of their offender. Since 2006, victims or family members have been able to share their experiences, including the impact of the crime, and voice their concerns in reference to the offender in face-to-face meetings with the board. The Parole Board is committed to allowing victims to be heard and will continue to hold this productive and fulfilling event throughout the state. The Victims Visitors Day involves all 5 board members attending and meeting with victims. Much of the agency's clemency staff participate, and in a confidential setting, crime victims, if they choose, meet with a parole board member and clemency staff to discuss the offender's case. Much of the parole board staff and staff with the Departments of Corrections and Community Supervision relocate to a Georgia community for the day, making the agencies accessible to more crime victims. The board's goal is to offer such a meeting with any victim of crime in Georgia who requests one. The Georgia Office of Victim Services works with the local Victim Witness Assistance Office within the Office of the District Attorney to facilitate the event. Victim Offender Dialogue, or VOD, is a program provided by the Georgia Office of Victim Services. VOD is a victim-centered, victim-initiated program that provides an opportunity for victims to have a structured, safe, one-on-one meeting with their offender. Victims are able to ask important questions that only the offender can answer. Victims initiate the request, and the offender must acknowledge responsibility for the crime. The process involves both the victim and the offender working separately with a trained facilitator through multiple meetings before the dialogue takes place. Victim Support Partners is a statewide network of dedicated victim volunteers who can aid, guide, and comfort victims and their families. This program was created in an effort to proactively engage victims and help them through challenges during the post-sentence phase of the criminal justice system. Their support includes sharing information about the parole process, identifying a victim's needs, and assisting with victim registration and impact statements. The Victim Support Partners also participate in Victim Services sponsored events, serve as guest speakers at community meetings, and promote restorative justice-themed programs offered by the Georgia Office of Victim Services. The Georgia Office of Victim Services serves as a liaison between crime victims and the State Board of Pardons and Paroles, Department of Corrections, and the Department of Community Supervision when receiving unwanted or threatening contact by the offender. The Georgia Office of Victim Services works with these agencies to address and resolve the unwanted contact in a confidential manner in order to assist the victim. Contact the Georgia Office of Victim Services to register as a victim or for more information regarding these services.